Last week, the Supreme Court heard arguments in a case that could overturn 7 convictions in one of the most infamous murders in Washington, D.C. history. At issue is whether prosecutors withheld evidence that could have acquitted the defendants, evidence they may have been legally required to disclose.
In October 1984, a 48-year-old mother of 6 named Catherine Fuller was found dead in an alley. She'd been beaten to death and sodomized with a pipe. There was no physical evidence linking anyone to the crime scene, but prosecutors used witness statements to convict 8 young men of first-degree murder. What prosecutors didn't disclose was that they'd also identified a separate suspect. Before a trial, prosecutors have to share any evidence that could acquit the defendant, even if the defendant doesn't ask for it. It's called Brady disclosure, after a 1963 Supreme Court case, Brady v. Maryland. There's no standard to determine which evidence qualifies, so prosecutors decide on their own. A defendant can challenge his conviction on Brady grounds if he can prove 3 things: that evidence was suppressed, that it's favorable to him, and that it could have affected the outcome of the trial. That's what the Supreme Court is now considering in the Fuller case. Here's the theory that prosecutors presented at the original trial. A gang of more than 10 people were hanging out in a park on the day of the murder. They spotted Fuller and decided to rob her. They forced her into the alley where they beat her, dragged her into a garage, and sodomized her. Here's the evidence prosecutors suppressed. The person who found Fuller's body saw 2 men in the alley. They both fled when the police arrived. The witness noticed one of the men hiding an object under his coat and identified him as someone named James McMillan.
Why was his name not given to the defense?
The policy of the Department of Justice was that if it is not required to disclose information, we will not provide it.
One federal judge recently called Brady violations an epidemic. Out of the 762 murder exonerations since 1989, 50% were Brady violations. James McMillan went on to commit 2 nearly identical attacks on women and is now serving life without parole. One of the 8 men convicted for the Fuller murder was let out on good behavior. Another died in prison. The other 6 have been incarcerated for the past 32 years.
We don't know how the trial would have shaped up and how the jury would have reacted if the defendants had put on this alternative theory. You can say, well, I probably would have failed, but the test is only, could a jury believe this scenario?